On this week's episode of Where We Are, we'll catch you up on some of the recent Supreme Court decisions, what they mean for you, what they mean for our politics. Glad to be with you. Thanks for listening to Where We Are. This is Where We Are. We are the Wheres. I'm Michael.
I'm Melissa.
Melissa, as you know, Where We Are podcast is brought to listeners in partnership with the That Sounds Fun Network. Mm-hmm. And we're so glad to partner with Annie Downs and her team over there. We recently got to partner with our friends at the Snack Show.
Yep, the Snack Show.
And that
with
was
Jamie and Fallon.
That was such a fun episode.
It was such a fun episode.
Glad to talk through presidential snacks.
For our 4th of July weekend.
Yep. So happy 4th for folks. Melissa?
Yeah?
We have a question for our audience.
Okay, what's the question? That's so funny because I have a question for our audience. And I didn't know you were going to do this. Okay, what's your question?
Yeah, my question for the audience is, we've been discussing this week whether we should do a sort of weekly ranking of the Republican candidates for the primary.
Uh-huh.
And I have a lot of thoughts. I'm following the race closely, not just what's sort of what the headlines are, but following the campaigns. I'm in conversation with a number of the campaigns. And so I think it could be helpful. On the other hand, I am very sensitive to those who would say votes don't even take place for another 7-8 months. The general election is a year and a half away.
Right. Can
we pump the brakes? And so really, we want to hear from you all.
Do you want a power ranking?
What level of, is it helpful at this point for us to, on a regular basis, be keeping you up to date on how the Republican primary is shaking out? Or is your general sense like, you know what, I don't care that much until we're like a week away from votes taking place, and then you can catch me up? And I'll be honest, I think the latter is a totally healthy perspective.
It is.
But we want to know what our audience wants. And so reach out to us on social media. Drop us a line at, what's the email?
We have an email now where you can send us questions in case you're just not on social media or whatever. It's wherewearepod@gmail.com. So it's the name of our podcast, WEAREPOD, wherewearepod@gmail.com.
Great. Let us know. And while you're there, if your answer is let's pump the brakes on 2024 coverage as like a regular weekly feature, let us know what you do want us to cover, because we have to talk about something. No, thank you for that. Melissa, though, I'm very intrigued by what question you have.
Do you want to know what the funniest thing? You and I are just so us constantly. And your question is like very related to the pod. And my question actually came up last night as I was watching TikTok, because I got a TikTok where, sorry guys, where they used the American Beauty main theme of the soundtrack, the piano piece. I should probably play it right now, because I don't know about you all. I saw American Beauty once, but this piano piece like haunts me. And whenever I hear it, like, I'm immediately like transported to like a place with that piece. And I was just sort of, I want to know, what's your favorite sort of soundtrack piece? Because I love talking about soundtracks.
That's a great question. Okay, favorite soundtrack piece. Melissa's throwing American Beauty in there. Melissa's looking to pull up the song. I got to throw in Phantom Thread. I have to throw in on Chesail Beach. Those are the two soundtracks that I wrote most of my next book to. I love both soundtracks very much. I have to add Atonement.
Yeah, I mean, Dario Marinelli, like, went hard on Atonement soundtrack. That soundtrack's a masterpiece.
As a millennial, I have to throw in Garden State. If you know, you know. I have to throw in Soul Food and The Best Man. And Waiting to Exhale.
That is so Michael.
That is so Michael. And those three soundtracks are exquisite. And really, if you haven't, you need Soul Food, Waiting to Exhale, and The Best Man. These are soundtracks you need in your life. And it was back in the day when like soundtracks. I mean, I know that they still soundtracks today will still include like new music, like
yeah.
But folks who are not of younger folks may not know that there was a time when like singles came out on soundtracks like regularly.
Yes.
Like you were buying soundtracks regularly. Like they were whole separate marketed things.
Yeah, you were buying Maya's song. You were buying the soundtrack to Rugrats, the movie, because of Maya's song back in like 1996. Yes.
Yeah. Okay, do you want to play this?
Yeah, I'll play the American Beauty song. I mean, my favorite soundtrack of all time is Interstellar because Hans Zimmer is my favorite composer. But this by Thomas Newman, I hear it and I don't even like know what to do with it. And I'm about to play it. It's just got, of course, a commercial, but here we go.
It's transporting. Like it's so wonderful.
My main thing is that if nostalgia had a sound, that would be what nostalgia sounds like. That song just screams nostalgia for me. Nostalgia is such an uncomfortable feeling for me, so that song makes me wildly uncomfortable and nostalgic. Yeah. But it's so beautiful. Like Thomas Newman just like hit it out of the park with that song. I don't even remember that movie. I've seen it once. But I know that piano piece.
Yeah.
Anyways, our question for
you. Yeah, so let us know if you have a favorite soundtrack, what it is. I mean, the soundtrack for, I have to add Closer.
Oh, you love him.
The Damien Rice stuff is just fantastic.
Remember I bought you that CD when we were dating?
So good.
Yeah.
All right, well, let's get to the news. We want to talk Supreme Court. And we're not going to get into the weeds of all of these cases. What I want to do is just kind of like sketch out a few points. We'll talk about some of the big cases and just kind of catch you up to speed. This has been another, there have been some headline cases in this as part of this docket. I think it's notable, before Thursday, the headline I had, Melissa, was that we are seeing a court that was making decisions that reflected to me the vision that some people have for the future of the Republican Party, which is sort of slightly less, less deferential to corporate interests. And to me, the Norfolk Southern case was emblematic of this. This was a 5-4 decision written by Neil Gorsuch that upheld a Pennsylvania law requiring corporations to consent to being sued in its courts as a condition for doing business in that state. Corporation argued for something more favorable that offered it stronger protection from lawsuits. An expected outcome to this case is that other states will move to similarly protect its citizens from corporations operating in their state.
Yeah.
Now, right? So, right. The textbook answer here, along with every other case, would be, this is not a political decision. This is sort of just interpreting the law, but it does. It was a 5-4 decision.
Yeah.
You had conservatives lining up alongside the progressives on the court for this ruling, and it does suggest to me, as a matter of just sort of, and of course I should say Gorsuch, a Trump appointee, that this is a more populist decision from the court.
Yeah, for sure.
You pair that, interestingly, Chief Justice John Roberts is historically antagonistic towards the Voting Rights Act. All right.
Yes.
And so this is a long-standing, going back to his Harvard Law days, and the court has made significant decisions undermining the Voting Rights Act. But in this docket, the court made a really important decision that surprised a lot of onlookers, rejecting Alabama's gerrymander, upholding a key application, a historical application of the Voting Rights Act, opening up the door in both in Alabama as well as in Louisiana and potentially in other states for a increase in the number of a black majority districts, congressional districts in these states. So, the basic background in this case is Alabama tried to put in place a gerrymander, which, despite Alabama having 7 congressional seats and 25% of voters being black, the court, in another 5-4 decision, this one, the 3 progressives were joined by John Roberts and Brett Kavanaugh. The court said that the Republican-dominated state legislature had denied African-American voters a reasonable chance to elect a second representative of their choice. And so these 2 decisions were earlier in the docket, and seemed to really often that's how these go, more consensus decisions, and also some surprises that are sort of contra the anticipated sort of political, ideological valence of the court can be earlier in the docket. And then, of course, we saw Thursday and Friday some more expectedly conservative decisions. But Melissa, I'll stop there. What thoughts do you have before we get to sort of the 3? I guess we could say the 4 interesting cases that came out in the last week. You have any thoughts on the Supreme Court up to this point? I guess I should say, Melissa.
Yeah, what?
Right, these decisions come in the midst of weeks and weeks of heavy scrutiny on the court.
Well, yeah.
around Clarence Thomas, around
Yes.
around Justice Alito, a lot of accusations and reporting around them being beneficiaries of sort of wealthy friends, and including some court activists like Leonard Leo of the Federalist Society. Accusations that these justices are essentially paid off. I will say I thought Jamel Bowie had a very good column on this week in which he explained, I think rightfully, that this is not so much a matter of justices being sort of paid for their opinions in a straightforward manner. I think what these stories suggest, of which there are analogs on the left, is the social infrastructure that's developed around these political divides.
Yes.
That
shouldn't be there.
Well,
It's
so.
I mean, it's more complex than what I just said. But.
It's more. Like these people have lives and
Sure.
friendships, and we know that sorting based on political ties has happened generally across the population.
Yes, absolutely.
And Melissa, like we've been at functions.
We have been.
We've been at functions where
with various members of the court.
With members of the court, and just more broadly, especially because it's such and I don't mean this in a pejorative way, but it is such a revolving door between these government positions and the advocacy groups. So a lot of people who are currently serving in the White House or on the courts or in roles of public office came from the advocacy groups. And a lot of people in the advocacy groups got there because they had just served in government. And so that's what I mean when I say like the social infrastructure that grows up around these political ties, particularly in a city like DC, where so much of the culture and is run by politics. That I'm not saying it's not a problem. I'm not saying that, but it's not. I don't think it's something that, in general, these sorts of ties. Again, obviously, if the law is being broken, it's being broken. But sort of fraternizing, being friends with people in advocacy roles, if you're in a position where they could feasibly want to influence you, I mean that's a lot of the relationship. I mean that's just social life. I don't know what you do. I don't know what you do about that, and I don't know if a law could be made sort of
Supreme Court
that.
Justices can't live in DC and they have to live elsewhere. They come in for the the docket, like the dockets that they have to get through and the decisions. But that would be absolutely wild.
Yeah, no, it would be wild, and I don't even think like that would
like even proximity would actually even make that big of a deal, because it wouldn't, because of the amount of power that they obviously attract, and they all come from like wealthy backgrounds. Maybe not originally, but like, to get onto the Supreme Court, you have to have been pretty successful in your career, and so you're hanging around other wealthy people. Like, it's not.
Yes, right.
That's just the social circles that you have built up because you are in your 50s or 60s or 70s and getting onto the bench. Yeah.
So I'm sorry for doing all that context setting, Melissa, but I did remember that was, I think, important and not like coincidental that leading into all these decisions.
Oh yeah.
Weeks of like intense scrutiny of
the personal lives.
The court. But so yeah, Melissa, before we get to some of the more controversial cases.
Yeah, I don't have many comments outside of the bigger cases that came down just a few days ago. The only thing that I'll say is, as usual, when you sort of get into the dicier, more contested, or the cases where we know that even with a court that is more bent towards conservatives these days, that it's always interesting reading the opinions and the dissent and things. How the language that the various whomever it is that's writing these things, the language towards one another is a lot more collegial. And then as we get into these more difficult cases, you can see the sort of fire under some people's butts that start to come out in terms of like, you can really tell that they deeply disagreed, or, you know, they're very, very for whatever decision is happening. And when they're referring to one another and how the other is writing their opinion or their dissent, oh man, you saw it this last week.
Blistering
some with the affirmative action, or with the 303 creative case, which we'll go over. And that, I think the inner workings and the inner machinations of like the relationships between these 9 people, I always find to be one of the most fascinating aspects. Yeah. But let's get into these other 4 that came down this week. So we've got the case on affirmative action. We've got the case on the web designer serving same-sex couples. We've got the case of the U.S. postal worker and observing Sabbath. And we've got the case of student loans, student loan debt, the Biden administration's policy plan to implement $10,000 or $20,000 in student loan debt relief. Which one would you like to start with?
Yeah. So just before we do that, I do want to read Sarah Isker, who was a Trump DOJ official, but sort of never Trumpy, or is now at the Dispatch, and is the conservative in the Left, Right, Center podcast, etc. She did tweet something that I thought was interesting before we move into the conversation about controversial opinions. She tweeted a fun SCOTUS stats from this term. 50% of the cases were unanimous in outcome. 89% had at least one of the liberal justices in the majority. 8%, only 8% were 6-3 decisions with the 6 Republican appointees all on one side, and only 3% were 5-4 decisions with the 3 Democratic appointees all on one side in dissent in all those 5-4 cases. I think that's important and notable. What it shouldn't do is so the pushback against that would be, well, Supreme Court takes up a lot of cases that don't have that clear of at least within like the dividing lines in our politics today, that clear of a partisan valence. And that's true, but that's almost kind of the point, which is like the Supreme Court, there are so much money is poured into advocacy around the Supreme Court, and there's so much of this idea that the court is just constantly made up of these sort of political decisions that are sort of the court imposing its will, and I think it's important to, as Sarah did here, sort of zoom back and say, well, actually, the work of the court in terms of the cases they take up is not just taking up sort of a docket of settling of sort of imposing the court's will on the most tender political issues of our time, and so I do think that that's helpful. Now, when you hear about the Supreme Court in the news, of course you aren't hearing it about unanimous decisions on some like regulation you've never heard of. When you hear about the Supreme Court, it's about these big like hot button issues, but that doesn't constitute, in terms of time spent, in terms of, again, like the quantity of cases that the court considers, it doesn't reflect the full work of the court. With that caveat, let's move to the controversial cases.
We're just like slowly inching our way towards come on.
Let's talk about the postal. I think let's start with the postal.
Yeah, that's the easier one.
So this was a unanimous decision. And for me, that's the headline. We have now another case in a building number of cases. Supreme Court deciding unanimously in a religious freedom case,
Right.
laying down markers. In this case, it's for employers. In something like Hosanna Tabor, it was sort of a message to government,
Yeah.
like, don't go past, this point. Like, we're giving you a framework to work within. So this case involved a Christian postal worker who refused to work on Sabbath for so that he could practice his religion. The court, again, unanimously sent the case back to the lower courts with the instruction that the lower courts must apply analysis that's industry specific, and so basically they're asking the lower court to uphold a more robust level of scrutiny to cases where employers want to deny a worker's religious freedom accommodation request. And so really interesting case. Again, because it was unanimous, because it's another in these long, over the last 20, 30 years, these notable Supreme Court decisions on religious freedom that I see as the Supreme Court trying to recast and re-solidify religious freedom doctrine in a country where religious demographics and religious understanding is changing rapidly. The Supreme Court is sort of asserting itself to, in some ways, move and set new boundaries, but in many cases, just to reaffirm religious freedom protections. Melissa, any thoughts on this case?
No, that's very straightforward.
Yeah, I think it's straightforward.
It does lead us into the next case, which obviously dealt with religious views, but was actually a case about free speech, which is the case of a web designer company called 303 Creative. That was the Supreme Court had to look at the anti-discrimination laws of the state of Colorado and whether or not they impinged on the free speech of this web designer who owns her own company, who was refusing to make a website for a potential wedding couple, a same-sex couple. So did Colorado's anti-discrimination laws actually impinge on the free speech rights of this web designer? And the court ruled in favor. I think what was it, a 6-3?
Yep,
a 6-3 ruling in favor of this web designer, saying that this Colorado anti-discrimination law impinged on her free speech rights.
Yeah. So importantly, it was not decided on religious freedom grounds.
Nope, free speech.
It's a free speech case. I think also, notably, what I'd say is I was seeing some David Brody. David Brody, shared this. David Brody was a longtime reporter for CBN News. He now is involved in a sort of new media effort. David Brody shared that this decision was, a major sort of win for Trump. He said really bad week for liberals, really great week for the U.S. Constitution. He said that this decision was a part of the Trump effect. I think the case is important. I think to the extent that you want to, the extent to which folks want to draft this into being an LGBT rights case, again, it's very important. The court decided this on free speech grounds, religious freedom, LGBT rights. That was definitely not central to the decision, and those aren't the grounds on which the case was decided. I just think it's really rich for there to be victory laps on this in the wake of, dozens of Republicans supporting the Respect for Marriage Act.
Yeah.
Neil Gorsuch, a Trump appointee, writing the decision in Bostock. And so it's just, it seems to me like the partisan impulse to claim victory is really like overcoming an analysis of where we are and where the law currently stands on these issues, and the role that Trump appointees have had in deciding against conservative religious freedom interests. And so that would be the thing I'd say on this case. I do think the progressive, the liberal justices' concern about this, there not being a limiting principle here, I think is a legitimate concern. I think conservatives would probably throw back that there wasn't quite explicitly, there wasn't a limiting principle in Obergefell when the Surgeon General said, like, well, maybe religious colleges will have the courts coming after them next. We'll like have to wait and see. And so just a lot of the culture war kind of issues now, part of the way that they function is that there is great disincentive towards there being limiting principles on either side, because everyone is terrified and everyone wants the other side to be terrified. And that's, not a healthy place to be in. But Melissa, any additional thoughts on 303 before we move on?
No, I don't.
Yeah. Let's talk affirmative action, and then we'll. So really we have two higher ed cases.
Yes, that is correct.
And our most listened to episode is on student loan debt.
Yeah, Michael and I had a debate.
And so we'll save that for the end. The affirmative action case, this was another 6-3 decision. And in this decision, the conservative justices accounted for the 6 and ruled that race-conscious admissions programs at Harvard and the University of North Carolina are unconstitutional. This is a very significant decision for a higher ed. There are more important things to say about it, but I do think it's, for the second time in just over a year, this was a victory lap moment for Justice Clarence Thomas.
Yes.
The victory lap he took last year was in the Dobbs case, in which he unnecessarily, in my view, wrote a concurring opinion that suggested that other precedents should be up for revision in a way that I think provoked a backlash that set his own ideological sort of desires backward. You'll remember the Respect for Marriage Act was basically advanced through Congress in response to those few lines in Thomas's opinion. And now in this case, Justice Thomas used it to use the decision in this affirmative action case to really advance his view of race relations in this country, and so he he made some. He said this is not 1958 or 1968. Today's youth do not shoulder moral debts of their ancestors. He described college admissions as having become a zero-sum game that has made Asian students suffer because of an overcorrection by courts during the civil rights era. And then we got to see Sotomayor and Justice Ketanji Brown Jackson, who wrote her own dissent, respond quite forcefully.
Yes.
And so this case really was a sort of a set piece of racial disagreement
Yes.
in this country, and competing narratives about
Yes.
both the meaning of our history and the state of race relations today in a way that's not all that dissimilar from the debate that's been playing out between Nikki Haley and Tim Scott and Barack Obama, that's being, taking place in the context of GOP primary and the 2024 election. So that's part of the context. Another piece that I'll add to this is that Chief Justice Roberts wrote the opinion, and this is not a original insight. What the court did not do is say that race cannot be racial experiences, and particularly adversity, cannot be considered in college admissions. And President Biden picked up on this. I participated in a call the White House held soon after the decision, and they emphasized significantly that they're going to be focused on responding to this decision, helping higher ed institutions respond to this decision by focusing on that sort of opening the Supreme Court gave, which is, yes, you can't sort of the fact of race alone can't dictate admissions policies, but whether it's through the admissions essay, which was particularly or specifically mentioned, or through other means, colleges can take into consideration adversity students have faced, including adversity because of racial discrimination, as part of the admissions process. And so for me, Melissa, like I think all in all, I don't think we were ready as a nation to do away with these kinds of with affirmative action policies. I do share, and David Brooks spoke about this week. I share David's. I do think the system was imperfect. I do think that the system was its stated purpose was carried out through means that were
that led to negative externalities.
Yes, that's a good way of putting it. And so I wouldn't say I'm hopeful in the sense that this is an opportunity for better systems to be devised that really get at accounting for adversity and accounting for various levels of privilege in the admissions process. Now, I don't have I'm not optimistic sort of our higher ed institutions will get it right, but I'm hopeful that this provides at least an opportunity for better systems to be created. I am, of course, concerned that we'll see a fallback in diversity in college admissions. I do wonder if the incentives and the commitment within higher ed institutions is such that generally is such that we won't see a slide back. We won't see gains reverse because higher ed institutions are have their own sort of stake in this with the growth of the administrative state of the administration of these higher ed institutions, their own professed values. And so a lot of people will be keeping an eye on it. Someone noted, unlike a lot of other things, we'll be able to know if there's an effect, what the effect of this Supreme Court decision is pretty soon, because there are admissions classes every year. And so, it won't take 15 years to determine whether the Supreme Court decision set back diversity. We'll have at least early returns on that, within the next 12, 18 months.
Yeah, I completely agree with you. I don't think our country was ready for this kind of ruling to come down. I do completely agree that the system was imperfect, but sometimes you have to go with the imperfect because we don't really have much else in place when it comes to trying to stem the sort of disadvantages that Black communities face across the United States writ large. We know that we know that in so many other areas of life, like when you go into like Black communities in a city, it's like a food desert quite often. We know that Black home ownership is still quite lower than like white home ownership. Like we have all kinds of signs that a lot of this stuff persists when you think about kids and the types of schools that they go to and that sort of thing. Like, of course, there's going to be more adversity. And so that's why affirmative action made sense, 40, 50 years ago, and why it technically still makes sense today, even if it was an imperfect system and led to negative externalities.
No.
But basically what this ruling does as well, like you were just saying, we're going to see pretty quickly through statistics what actually happens at Harvard, at North Carolina, and at other universities, because it's not just going to be them, is how well ad hoc university to university, college to college actually deals with trying to create some sort of level of diversity or equity or system or quote, whatever, that appears like affirmative action but isn't. But it's just there when it comes to big problems like this where, affirmative action was just sort of one way of trying to solve the entire enchilada of racial relations in this country. Like it takes much more than that. And that's also another reason why it was so imperfect is because so much burden was being placed on that specific practice when we don't have a heck of a lot else to actually help the issue. Is that, I always worry when we go from a system where it is sort of top down putting sort of rules in place. I always get more worried when rules suddenly become very, very decentralized and we'll go school by school by school in terms of the whole, what the higher education sort of apparatus.
But that is
like.
what we have.
I know. But
I mean, there was no. All these schools' admissions policies were decided by the schools themselves. These weren't.
Yes, but the affirmative action sort of. One of the reasons why this is so upsetting to folks who are in favor of affirmative action is because of like the cultural aspect, the symbolism aspect of it all as well. That's what I'm talking about, like a sort of more centralized rule that schools could follow in how they actually made their admissions decisions.
Right. Right. Affirmative race-conscious affirmative action programs allowed for at least like the appearance, and I think it's fair to say that there was some sort of direct influence of like a blunt of a blunt instrument that was directed towards this, and now now that the instrument has been dulled
yes.
in the admissions process has been dulled when it comes to racial preference, and so I think that I think there's definitely legitimate concern about what the fallout of that's going to be. Huh.
Yes, especially at a time when higher education has a lot of problems, and the cost of education is high, and how your jobs are so dependent on where you went to school, prestige, all of that really affects, obviously, the entirety of a person's life.
Yeah.
All the way through retirement.
Yeah, I will say, just to like close out, like I spoke sort of vaguely to this before. One of the things I hope that we'll do is use this as an opportunity to consider more heavily factoring income and like the court struck this down based on the idea that that there are like civil rights laws against using race to dictate access to goods and services and in this case like higher ed. There is no constitutional provision against considering, again, the adversity factor, the income factor, the class factor, and we should think about, because that's really what we're trying to get at when you talk about, and that is a way of providing. There's a tool in the box that we have not adequately used for making sure that our higher ed institutions reflect the country, and that is to make sure that lower income students have access to higher ed institutions. And so I hope that that this may open up opportunities for revisiting how those kinds of factors are considered.
Mm-hmm. So, speaking of the cost of education,
good transition.
Student loan debt.
Yes.
The Biden administration's plans to relieve people under a certain income amount of either $10,000 or $20,000 if you had Pell Grants has been struck down. Specifically under the idea that the Biden administration was trying to work this policy through the HEROES Act from the early 2000s. And it was very interesting that the Biden administration was extremely prepared for this ruling to come down, because within hours of it, we had the White House, the Department of Education coming out and saying that they were going to propose a bunch of new income-based rules to provide relief for folks, but the very first thing would be to go after this kind of relief again, but this time through the Higher Education Act, or the HEA, which is a different piece of legislation from the HEROES Act. But they already put out the warning that this would take time, because they have to essentially.
It's a very delicate rules process where it has to be followed. That now that they know that the courts are going to be looking for ways to cut off workarounds from this ruling, and so they just need to follow the regulation process to the T, or the rulemaking process.
Yeah.
To the T.
So now it will take longer, and because of that, because some of the things are so uncertain as to exactly who would benefit from relief. It's another reason why the whole thing is just
and they know.
Mess.
I mean, so this is important. Like they basically, the Department of Education, the Biden administration basically knows, but they can't say it because they can't prejudge the rulemaking process.
Yes. They can't say, okay, everybody with $150,000 or less will be able to qualify. It's going to be a bunch of something
they
about
have to do
the poverty
public hearing.
line.
Well, they have to do public hearings. There has to be like a whole thing. And anything else you wanna cover on this?
No, but we've got this election, and clearly they still think it's important enough for them to have had an entire plan for when it was struck down. to continue to entice the folks who this was important to. But the fact that they don't have an answer yet as to who will benefit will definitely be a burden to them politically, because they won't be able to in a very clear way tell people like you know this is gonna, you know, that $10,000 or $20,000 you thought you were suddenly gonna have, yep, you're gonna have it back. Like they can't tell that to a single person right now. And that just leads us to what Michael and I, what drove us wild about, as soon as, you know, this policy came out and within like a few days, everybody was saying legally this is going to be challenged and probably will fall, is that the fact that the Biden administration would have gone down this route after having very talented people on their legal team take a look at it and not flagged it in this way is absolutely wild to us. You cannot dangle actual money, not just like, oh, here's like a tax break if you have to qualify for this. Real $10,000 or $20,000 material money to a huge swath of people, millions upon millions of people.
Tens of millions of people applied for this,
and then take it away from them. You can't have made this kind of sort of unilateral, like executive move only to have it taken away. And absolutely,
because it's not a unilateral move. We have like a system of government.
Yes.
I just find it, Melissa, and for folks who have listened, we've been talking about this for months. And, you know, I told people this is how it was going to go, and it went this way. And I find it to be cynical. I find it to be so cynical. And, you know, maybe, like, I want to leave some room for, you know, maybe they didn't know it was going to go this way. But again, and it was in the case. Speaker Pelosi in like 2020 said the president just can't do this.
Yeah.
Biden was well on the record. And so here's the cynical read on this, which is Biden needed to get progressives off his back on some for some issues. So they made a decision to do this, to put this forward, if not knowing, at least, you know, 80% expecting that the courts would shut it down, that the courts would not allow them to move forward. But they figured if that happens, we could blame the courts, we could blame Trump. We did what the progressives wanted, and we could blame the courts and Republicans for not letting it get done. You know, they're still tweeting out, every Republican who held the decision. The Biden White House is tweeting out about, you know, the COVID, the PPP loans they took, and I just think it's so. I find it to be unserious. I think that there are millions of Americans who do not follow the courts, who aren't following the ins and outs, but were asked to apply to the Department of Education for what seemed like a very straightforward program, which is, if you have this amount of loans and if you have this level of income, your loans up to this amount will be canceled. And as of right now, there is no reliable, immediate, transparent plan for how those loans will be canceled, forgiven, and payments are going to start kicking in. Now, the Department of Education there's going to be like a year transition period where if you miss a payment, it won't affect your credit rating and sort of these various things. Look, I just think if you take this shot, you're responsible for having it go through. And I just thought it was laughable on its face that a COVID bill was going to be determined to be sufficient grounds for the executive branch unilaterally forgiving millions and millions and millions and millions and millions of student loans. So now here's what I will say. To the administration's credit, they were much more reserved. Like if you compare their response to this decision and their response to the affirmative action decision, almost night and day. So to their credit, they did not make grandiose statements about this being a rigged court, or not in response to the student loan decision. The president said he thought it was a wrong decision. They announced a plan to move forward, but they didn't respond with heavily partisan rhetoric against the court. I think because they knew they didn't have the strongest case. That's one. And so I will give them I will give them credit for that. They sort of they couldn't move it through Congress. They tried to do it on their own. They're respecting the court's decision. There was no we're going to do it anyway, or sort of no, they are respecting the court's decision, and they announced a plan that's in line with honoring the court's decision. But gosh, I don't like how this has played out for people who were really counting on those resources.
Yeah, people were already planning their life because of that kind of resource being lifted off of them, and I just cannot believe policy. There's all the political machinations, just policy-wise, just how much it was bungled from a policy-making standpoint. And also, honestly, my more cynical take is that the administration was much more subdued on its response because they knew that they shoulder completely all of the blame in terms of it failing, because they should have seen this coming and they shouldn't have done it this way. And if I were them, I would make sure that my response is quiet so that the focus could be elsewhere.
Well, yeah. Right. And that's the thing, if they would have said, like, you can't say, hey, we're going to try this, but we don't know if the courts will accept it, because then you're basically admitting defeat before the case. But because they couldn't do that, what they had to do was say, this is happening. I think they collected these applications in part so that the Supreme Court felt like, oh gosh, this is already moving forward. Like, are we really going to, tens of millions of Americans have applied, are we really going to do something so grand as to intervene on the executive branch moving forward this policy? But the answer was yes. Yes, the Supreme Court will do that. And in order to sell the plan, and sell the plan around, in advance of midterms too, there had to be this sort of, this is happening kind of like, I don't know, Melissa, did you get a whole lot of when you saw the president, Secretary of Education, when they rolled this out, I didn't get a whole lot of, we'll see if this happens sort of vibes. It was like an announcement. It was like, apply now. This is happening. We're delivering on the promise from 2020. And I don't know, like I think there needs to be responsibility here. And it's not just, I saw someone share some, like, one of those, tweeters who's on the White House's tweet list. One of their talkers, said, but Biden did everything we asked of him. This isn't his responsibility; it's the courts. Blame the court. And I'm no.
The buck stops with the policy.
The buck stops with the policy, and this is not. Again, this decision was not a surprise.
No.
If this decision came out of left field, then you could say, well, how? how were they supposed to know that the court would step in on this? But the second the decision came out, everyone was like, oh, I'm not sure if I don't think the courts are going to accept this. Mm-hmm. I think that's a good sign that responsibility doesn't just lie with the courts. It lies with the people who made the decisions to proceed in this way. Mm-hmm. So, all right. Well, that is the Supreme Court roundup. I don't think anything happened over the last couple of weeks that is going to sort of like mollify Supreme Court critics on the left. Part of the fact of the matter is Supreme Court critics on the left won't be mollified until the balance of the Supreme Court is more favorable to the left. And then we'll have conservative critics, like we had for years, about the injustice of the progressive activist court on the left. And that's just the way these things go.
Yeah, as Bruce Almighty would say, that is just the way the cookie crumbles.
It is. We need a religious freedom case about Bruce Almighty, I think, hitting the court. All right. Well, I hope that was helpful to you all sifting through. I don't know if you're like me, but the Supreme Court announcements are released at usually around 10 in the morning during the weekday. So you get these headlines, but we'll have varying levels of capacity to stop what we're doing and actually figure out what happened. And so we wanted to take this episode to walk you through some of the contours. All right, that's all for this episode of Where We Are. Thanks for listening. As always, we'll be back with the Morning 5 this week and a new episode of Where We Are next weekend. Happy 4th.
Bye.
It's the end of the weekend, but I still wanna turn up. Yeah, I still wanna turn up. All I want is to go again, but you ain't picking your phone up. Why you mess